for today's compliance update. Take away, Heidi.
Thank you, Jeff. I'm sure my transition here will be just flawless. Are you seeing?
We are seeing it.
Screen? Yeah, great. Okay, so introduction and disclaimer. Those of you who have attended the session before, welcome back. For those that don't know me, again, my name is Heidi Seaton. I'm the VP of Legal and Compliance here at Orange Tree Employment Screening. I do stop at this slide. I must. I'm an attorney. I'm not your attorney. I think that's the important takeaway from this slide is if you have questions, if you have a particular situation or a policy or procedure that you're trying to implement, I just urge you to consult with your own legal advice or legal resource related to your questions. I really spent time here with you today to talk to you about things that I'm seeing in the market, things that I'm seeing related to statutes, regulations, litigation, to give you things to be thinking about, to be taking into consideration as you're implementing your programs. So we try to leave time at the end for me to answer questions. I answer whatever I can, but I just want to be a little bit careful about not giving you legal advice. So all of that having been said, let me see if I can get to the next slide. Nope, I can't. Hold on. There we go, the agenda. You know, a lot to cover today, actually. We have, how would we say it? A little to cover on a lot of topics. So we've got some ban the box, fair chance, and salary history. Mostly just reminders, a few updates and new things happening there. Some updates regarding some of the record access issues we're seeing in a few states. Some news on I-9, which is interesting. We haven't heard much about I-9 lately. We'll talk about a interesting case coming out of FCRA litigation. We did just have a session with our friends at Current Consulting Group about drug testing, but I am just going to quickly sort of give a lay of the land, what happened here in 2021, talk about 3 states in particular that I just want to make sure people are paying attention to. And then a little bit just on employment background screening industry news, just a slide there. So I think we'll have plenty of time to get through my slides today, but we'll see how we go. So starting with ban the box, fair chance, and decriminalization. So again, ban the box is that effort to remove the question about criminal history from the initial job application. Right now, we see about 36 states, about 150 cities and counties that have legislated related to either ban the box or fair chance, which sort of includes ban the box and then sort of also extends usually to some sort of ensuring consideration of individualized consideration of individuals that have criminal history in your hiring process. Recall applicability of these laws and statutes can vary widely. So in many cases, especially here at the statewide or the state level, the ordinance applies only to public employers, but public employer legislation, as we've seen over time, generally is the first step towards legislation that also includes private employers. So when we can here on the slides, I indicate, you know, here's a case where it's applicable to a public employer and not a private employer, or where it's both. So California, I'm going to start, actually, I've got 2 states with enforcement activity, which we never hear about. So I wanted to just bring these 2 up for discussion or to give it some visibility. California's Department of Fair Employment and Housing Agency announced an effort to identify and correct violations of the Fair Chance Act. So recall, the Fair Chance Act is not new. It's been around since 2018. It prohibited employers with 5 or more employees in California from asking candidates about their criminal history before making them a job offer. Fairly common way that fair chance laws or ban the box laws is implemented. For this enforcement activity happened here in October of this year, and the DFEH focused really on job advertisements. So they were looking for advertisements They looked very specifically for cases where employers used language that they think is problematic. So for instance, something like candidate must have a clean record. And they identified that as a violation of the Fair Chance Act requirement that employers consider applicants' criminal history on an individualized basis, right? So automatically excluding someone from being eligible for the job especially at the job posting stage, they said is very clearly a violation of the Fair Chance Act. They did this mass search of online job advertisements looking for this. They provided notices to those employers to remove the unlawful statements. They found over 500 advertisements. So interesting, kind of surprising, especially in California, but a lot of action there. They also came out with a toolkit. So if you get a chance, if you jot down that URL or just Google DFEH toolkit in California, it'll bring you right to that site. It's sort of a step-by-step guide for California employers on helping them to ensure that they are meeting the requirements of that Fair Chance Act. A lot of it, is related to how you're doing advertising about your job posting, and then the individualized assessment process, and then the consideration process. So not necessarily directly related to, making disclosure, getting authorization, doing the adverse action process, which Orange Tree is very often helping our clients with, but sort of on the other ends of those two processes. So very interesting to see some enforcement activity, especially when we also saw enforcement activity in New Jersey. So again, I almost never see enforcement activity on these ban the box legislation. Usually it's litigation, right? But the states have the authority to bring enforcement actions. So they are doing it. We saw it happen also in September in New Jersey. It was a much smaller group of employers. They identified 15 companies that were allegedly violating New Jersey's law related to the ban of use of language on employment advertising. Again, so they seem to be focusing on that very earliest step in the process where employers are posting information about the job itself and getting language excluding people with criminal history out of those postings. And again, just recall in New Jersey, not a new law. This is a law that took effect in 2015, and it prohibited employers with 15 or more employees from requiring job applicants to complete any form of the initial employment application process that complete any form during the initial employment application process that asked about criminal record, and also prohibited the employer from making any inquiry regarding criminal record prior to a first interview. And this also in New Jersey is the Opportunity to Compete Act, which bars employers from soliciting applicants for jobs through advertisements that say the employer won't consider anyone who has criminal records. So there are certain exceptions to that, but in general, it's interesting to see these agencies moving forward with enforcement activity in these two states. I kind of sort of expect to see more of this going on, especially as the labor market continues to be tight. So those two. We also then have one outright new ban the box change, and that is in Orange County, Florida. So Orange County, they're enacted a policy change. So this applies only to government employees, county government employees. So this is a good example of a change that's applicable only to public employers, in this case, county employment. It went into effect right away. So it was effective October of 2021. And the county just basically has removed the question about criminal history from their employment application, subject to some positions, public safety positions mostly. And that was about the only new one that we saw come through ban the box wise for new legislation in this latest quarter or since the last time we met. But we have actually had a fair amount of action here on ban the box over the last in 2021. So I do still have a few I wanted to just remind people about and a few that have updates. The ones especially where there's a significant requirement for the employer. So I start off here on my reminders with Louisiana. Louisiana passed fair chance legislation in June, and it was effective here in August. So a little old for us to be covering today, but again, it's significant for Louisiana employers. It applies to public and private employers with 20 or more employees in the state of Louisiana, and limits a few things, right? So employers can't consider arrest records or charges that didn't result in a conviction. So that's an approach we sometimes see with fair chance legislation, but not always. And for other criminal history, so convictions, employers have to complete an individualized assessment on whether the criminal history has a direct and adverse relationship with the specific duties of the job. So basically an individualized assessment. And then they lay out in the statute the factors that the employer has to consider. As you're looking at those 3 bullet points, maybe you're thinking, oh, those sound like the green factors. They do to me as well, right? That's those are the factors that came out of a case law that's been around for a number of years. But they're really looking for the employer to be thinking about the nature and gravity of the offense, the time that's elapsed since the offense, the conduct or the conviction, and the nature of the job sought. So in Louisiana employers, just make sure you're being really careful about your policies related to background screening. Look for and try to eliminate any red line policies. So any policies that say, we don't hire anyone with a conviction, or we don't hire anyone with a felony. In Louisiana now, they're very clear for public and private employers with more than 20 employees in Louisiana, you really want to make sure that you are doing and documenting your individualized assessment for candidates or new hires in that state where you are considering withdrawing an offer or taking an adverse action based on the criminal history information. They threw in another requirement under this legislation. Again, don't see this very terribly often coming in under fair chance legislation, but they said that a candidate can make a written request for any background check information used during the hiring process. So broader than the federal pre-adverse action notice requirement. You wouldn't necessarily have to be taking a an adverse action or pre-adverse action in order to be obliged to respond to a request like this that you receive from a candidate. So it would potentially be a background check provided by a consumer reporting agency like Orange Tree, and also consider it would be applicable if you're doing any internal screening, if you're doing social media screening, if you are doing any other internal screening separate from what you're getting from your background screening company, potentially that would also come under this law. So be thinking about that and be thinking about inputting or putting procedures in place to fulfill these requests when you get them. And then just a reminder here, Louisiana already had banned the box, but it only applied to state employment. And it said that employers couldn't ask about criminal history records until after the interview. So this is sort of a layer on that we do see with ban the box and fair chance legislation of it going in this trajectory of starting with legislation related to a public employer, government employment, and then later legislation focuses on private employers. So that's Louisiana. Maine also here happened in July, but there's an October effective date. So if you are a Maine employer, be paying attention to this and that effective date. This also was ban the box legislation, also applies to private employers. And it says employers can't request criminal history information on the initial job application or anytime before the employer determines that the applicant is otherwise qualified for the job. So a little less than definitive in when it applies, but certainly you want to make sure it's not on the job application, and then put procedures in place to not initiate the background check or ask for criminal history information until you get through that qualification process in your hiring process. As we saw, California, with the 2 states that were doing enforcement, also focusing here on not including information in job postings that would cause someone to decide not to apply. Right, so you want to make sure that your take a look at your job postings, make sure that they don't have language that would suppress people from applying, or that might deter someone with a criminal history from applying for your positions, unless it's a position that's regulated by state or federal law that mandates some sort of criminal conviction disqualification. So again, Maine, not new information here, but worth talking about again. And New York City, again, I know we've talked about New York City, the Fair Chance Act in a few sessions. This change actually happened in 2020, had a July effective date. But I think employers are still trying to figure out what it means, how to comply with it. So I want to just go through it one more time. We did get guidance from the regulators on June 15th. I've got a link there to it. It's worth a read. If you have any employees if you have any employees in New York City, you want to be thinking about how to implement this New York City requirement. Basically, the guidance explains that, as hard as it is to believe, so the guidance redefines, in my opinion, what a conditional offer is. It says a conditional offer of employment, promotion, or transfer is one that can be revoked only based on the results of a criminal background check or a medical exam, or other information that the employer couldn't have reasonably known before making the conditional offer. So, and then it says, so that's different. And the difference there, so I get a few questions about this, and people ask me about, well, should I be doing a 2-step process if I'm doing, any kind of screening that's not after the conditional offer for employment? The difference here is that in other states and other jurisdictions that we're aware of, the employer, it's always best practice to do the background check, including asking for criminal history information after their conditional offer is made. The difference here in New York City is this says the employer shouldn't do any other background checks other than criminal, and the exception is driving, other than criminal and driving checks after the conditional offer. So basically what the guidance is saying here is, hey, employer, do any other background screening that you need to do to disqualify this applicant before you make that conditional offer. Because once you make that conditional offer, the only reason you can then withdraw that offer is based on the content of the criminal part of the background screen. And again, they clarified driving probably can go along with the criminal part of the background screen. But they're concerned, I think, that employers are using other things in the background check as an excuse to withdraw the offer, and not admitting that they're using criminal history information. And so they came up with this scheme and this guidance. So New York City employers really be thinking about this. Timing is everything. They do say, hey, employer, if you don't have any way to do a 2-step background screening process, then you have to have procedures in place to stop the decision maker from being able to see criminal history information until after the conditional offer is made, which is, who can do that, right? What HR systems or software helps an employer separate out the different parts of the background check, so that one group can see, only one group can see criminal history, and some other group potentially could see the verification results or whatever the other parts of the background screen. So I think they're pretty clear that they are looking for employers to be doing this two-step process. And then there are additional requirements, right? So the Fair Credit Reporting Act still applies. You still got to make disclosures, get authorization, which means potentially you're making two sets of, disclosure and authorization, one for the preconditional offer background check, one for the post-conditional offer background check. And then if there is a criminal record in that post-offer portion of the background check, they refer employers back to the Fair Credit Reporting Act requirements around pre-adverse action, the Article 23A requirements about what criminal history information employers can and cannot use in their hiring decision, and then the New York City Fair Chance form process, which is a whole special form that New York City employers have to fill out and provide to their candidate if they are considering taking an adverse action based on the criminal history information. So that's a long time to talk about New York City, I'm sorry, but it's different. It's a little bit, it's not really like any other fair chance or ban the box ordinances that we've seen. And it's hard to conceptualize because it redefines what employers think of as a conditional offer of employment. And so that point is important to have an understanding about. So if you have questions about that, let us know, and I'll move on.
Heidi, not to interrupt you, but we did have one question about that. Could you quickly cover that?
I'll try.
Rebecca Ansley asked, does the New York update apply to employers who are based in Illinois, for example, but may hire remote employees in New York?
Look closely at the guidance on that question. In general, I would say, again, I can't give a legal opinion, we should be thinking about individuals who will be working in New York City, and that the applicability question is there.
Yeah.
Okay. Nevada, another just reminder quick, because this went into effect here since the last time we had a session. Nevada passed a bill in June, and it's another, actually this one is a little different. This is a salary history ban issue. So what's that? Salary history ban is states have begun enacting legislation that make inquiries into salary history prohibited for an employment decision. So right now, Alabama, California, Connecticut, Delaware, Hawaii, I probably shouldn't list them out, but Illinois, Maine, Maryland, Massachusetts, Michigan, Nevada, New Jersey, New York, North Carolina, Oregon, Pennsylvania, Vermont, Virginia, Washington, Wisconsin. Basically, it's become a best practice for employers to not ask for salary history information. Again, as part of the pre-employment screening process, legislators are looking to stop employers from using salary history to make a decision about whether to hire someone, and also to use salary history to make a decision about potentially what to pay them, right? So this is all about trying to ensure fairness related to salary. Nevada is just the latest, and we haven't seen too much action on salary history, but it has come up a few times. So we're just adding Nevada to the list. And specifically, employers can't seek salary history of an applicant for employment, rely on that history to determine whether to offer employment or how much to pay them, or discriminate in the form of refusing to interview, hire, or promote based on provided salary history. No exception there for if a applicant or an employee voluntarily discloses their salary. So I would just say, as much as you can, Nevada employers keep that topic off the table. Moving on, next topic is access, information access. So we're mostly, again, going to talk about Michigan and California. We talked about those two states last time. We've had an update in both of those states, not necessarily good news in either state. But just to give a little background on what this issue is, we have a few states, Michigan and California, that are systematically, and in this case, in the case of Michigan, through a court rule, redacting personal identifiers from court records that are accessible to the public. That's bad news for employers. That's bad news for people who want to use a background screening report to try to help them to mitigate their risk related to negligent hiring or negligent retention. And so background screening companies like Orange Tree, the PBSA, the Professional Background Screening Agency, are working towards getting these rules changed. Last time we talked about, there was an effective date that was supposed to be July 1st that did get postponed by the courts in Michigan. It got moved back to a 1/1/2022 effective date. And we're hopeful that we'll see some change yet to that court rule before that effective date. PBSA is lobbying. There was also a bill introduced in the legislature in Michigan, and it made it through the House, and it was taken up by the Senate, sort of got immediately referred to a committee, but I think it is not, it's not dead yet. So we are crossing our fingers on that one. In the meantime, we did see courts start to slow down. Our ability to get records confirmed in Michigan slowed down. And then the court did issue a letter to all of the court clerks saying, hey, this new rule is not effective until January 1, 2022. So, don't use it. Don't use that rule as an excuse to not provide personal identifiers between now and then. Somewhat effective, right? I don't think we've seen more courts refusing to provide identifiers on public terminals, but not sure that we turned any, that letter turned any of the court clerks around either that were already doing it. So again, what does this mean for employers? It means delay mostly in Michigan, right? So courts are, if they've taken off personal identifiers from the court records that are accessible to the public, that just means anytime when we're running a search for you and we get a name match, and if it's a common name or if there aren't any other identifiers on the public terminal, that we have to submit those requests to the court clerk for them to try to confirm additional identifiers for us. And so it just, it extends, it takes a little bit longer. It generally only affects searches where there's a possible match. But just remember, common name matches, are just as likely to come back as end up being clears as they are to be a record. So don't make assumptions, employers, about records in Michigan or California that are going wrong, that means there necessarily is going to be a record at the end of it. It means we just don't know, and we have to wait for the clerks to get back to us. So that is Michigan. California, you may remember, so they had a court rule that came out of us, all of us or none of us versus Hamrick. And the court interpreted the statute in a way that we just feel really overreached, but it went up to the Court of Appeals. We had an amicus, or PBSA, I should say, had an amicus brief filed in the case, and the court declined to review it. So at this point in California, we are seeing courts continue to redact dates of birth, especially from both online and public access terminals, which again, also for California means delays, potentially delays with common names or possible records, especially. And California, California's never been a terribly easy state for criminal records, right? But I don't see that letting up over time here. And I think, the approach is just going to be employers be thinking about, is there anything you want to do related to your conditional offer process, right? Do you want to allow someone potentially to start, even though a record is possibly pending, or research is pending out of California? Do you want to hold the line? We definitely are not seeing an across the board issue in California. Some counties are a lot worse than other counties, and so a case-by-case basis might be the best approach. That is how we are taking it here from a research standpoint. And we are also seeing some luck with just spreading out requests a little bit. So sometimes the court clerk will work on just a certain number of requests for each researcher for that day, and then they move on to the next one. So potentially spreading out the requests a little bit has helped us. So more to come on California. Again, PBSA continues to work on perhaps getting a bill together into the California legislature. It just has become somewhat political, and I'm not sure in the current environment that a bill like that would pass. But we are keeping an eye on it. So moving on then to a couple of federal topics. So in October, the Department of Homeland Security requested comments regarding remote document expiration practices. So this is big news actually for employers. I'm super hopeful that this request for comment is an inkling, or that the DHS is showing some willingness to adopt their remote document examination practices that were allowed because of COVID, past the COVID expiration timeframe. So again, to just give a little background, back in March of 2020, due to the pandemic, the DHS announced it would allow for deferral of the physical presence requirement in the Form I-9 inspection of identity and work eligibility documents. So anyone that's an HR professional, I-9, years and years and years, you always had to do that in person. And so they backed off a little bit on that in March of 2020 for COVID, and permitted employers with employees taking physical proximity precautions to examine those documents remotely. It applied to employers with workplaces that were operating remotely. So it didn't apply to employers, that were operating in person. You did have to be mitigating some COVID-19 precautions, or implementing some COVID-19 precautions in order to take advantage of the exception. But it's been, I think, very well received by employers. And so I'm encouraged by the DHS's willingness to take comments about potentially if it's something they want to continue post-COVID. Right now, the exception, or what they call prosecutorial discretion, is effective until the end of this year. So I'm not certain that they could still extend that, but minimally, I like that they're asking for comments from employers, and employers have until the end of December 27th to make those comments if they're interested. Also federal topic, FCRA litigation. We haven't talked about this much lately, but for those of you that remember, you might remember this case from a few years ago. It's called Walker v. Fred Myers. In that case, Walker, the plaintiff, was hired by Fred Myers. This was back in 2017. And then he was terminated a month after he was hired due to information that was uncovered during his background checks. So Walker filed a lawsuit claiming that the employer had violated the FCRA's standalone requirement by disclosure standalone requirement by including extraneous information in their background check disclosure form. In this case, and I think this is an important piece of information about the facts of this case, the extraneous information on the form was an explanation of the applicant's rights under federal and state law. We'll come back to why I think that's important. Anyway, the district court had dismissed the lawsuit, but then the Court of Appeals for the Ninth Circuit took it up. They affirmed in part and reversed in part and remanded. They also at that point adopted a concise explanation standard to judge when an employer's consumer report disclosure form was a violation of FCR's standalone requirement. And they said this was the case where they actually sort of laid out the things that could and should not be included in your standalone FCRA disclosure. And so this was very interesting case at the time. We now have a decision on the part of the case that got remanded, right? So the part of the case that got remanded went back for a decision, and the holding here was that that the employer's disclosure was clear and conspicuous as required under the FCRA, and that its failure to comply with FCRA's standalone requirement was not willful. I think, though, if you look at the opinion, we'll find the reason that they found it not willful was because this opinion about that new standard for what's standalone didn't happen until 2018. The form came out in 2017. So they basically just said, hey, there was no standard for what is standalone until that opinion in 2018. So therefore it's not willful. So narrow facts here. I think employers still need to be really careful that they're looking at their disclosure, removing any extraneous information. I think the timing of this particular case and the specific facts around it were really important. I don't think that standalone disclosure FCRA cases are going to go away based on this opinion, but I did want to just bring it back and talk about it quickly because it sort of closed the loop on this particular case that gave us that standalone requirement definition. Okay, moving on, drug testing. So we usually do a little bit of time in this session on drug testing. I've just included a really great map here from our friends at Current Consulting Group. They did a session with Orange Tree just last month. Covered a lot of the topics related to legalization of marijuana. Just quickly, 2021 overview, we had just one state that legislated legalized medical marijuana. We had a number of states that legalized recreational marijuana. I think the discussions and the statutes related to recreational marijuana use are more interesting and more germane to employers. And so we can focus a little bit more on that. But in 2021, we had Connecticut, New Mexico, Virginia, New York, and then New Jersey actually passed in 2020, but it didn't get implemented till 2021. So we'll count those. And then we also had a number of states that legislated related to marijuana discrimination. And so by that, I just mean it was legislation that created some sort of legal protection for users of recreational marijuana. And it's not always, full protection, and in many cases there are lots of things or considerations or parts of that legislation that touches on what employers may and may not consider in use of recreational marijuana, but states to be thinking about and looking at related to that marijuana discrimination, or I should say states, District of Columbia, Montana, Connecticut, New Jersey, again, New York. So just to give you, again, the three ones that I think employers should be paying attention to. New Mexico, that again was recreational marijuana legislation that said individuals 21 and older can legally possess cannabis as of the end of June here of this year. Recreational sales are expected to begin in April of 2022. Employers are provided certain protections under the legislation in New Mexico. They can still permit employers to the law still permits employers to maintain a zero tolerance policy, but use some care there in New Mexico. Check the statutes in particular. New Jersey, again, another recreational marijuana law that was passed. That was a voter public question that got passed. And then there was 3 bills in February pertaining to recreational marijuana. AB 21 and contained guidance specifically for employers, including standards for drug testing and impairment recognition experts. So if you are in New Jersey and you're drug testing, pay attention to that legislation. And then New York, recreational marijuana law, again, generally speaking, very restrictive towards employers. So if you are in New York and you're testing for marijuana, take a look at that statute as well. And then our last topic today, just a quick plug for the Professional Background Screening Association and HR.com survey of background screening trends. Very, very interesting information coming out of that. This is their 5th annual survey. We can get you a link to the survey. I should have put it in the slide, sorry. But again, reporting around employers that participated, 95% of employers, of US employers, said that they participate or that they do background screening. Slightly less of employers with no US presence said about 79% of them said that they do background screening. Still really high actually for international. Again, there's the prevalence of doing the background screening process post-offer. In the US, 73% of participants said that they're screening post-offer. And only 42% said they're screening post-offer internationally. And then the top 3 reasons employers are background screening, we actually had a change there in the top 3, which is first time in 5 years, right? So number 1 stayed the same, protecting employees and customers. Number 2 stayed the same, improving the quality of hires. Number 3 is the new top 3 response, and that was to protect company reputation. And that edged out for the first time. Companies said the legal or regulatory requirements that were driving their background screening program. So very interesting. If you haven't had a chance to read through it, take a look at it. It goes in depth to not only screening and when, but what types of screening services employers are doing. So interesting trends there as well.
Thank you, Heidi. We did have a question earlier related to, I think it's the Michigan, the date of birth redactment.
Oh, yeah.
We had somebody ask, what happens when a clerk responds that they will not provide information?
We haven't had clerks respond saying that they won't provide it. It's just that it's taking them a long time to get through the work. If we really, if it gets to, January 1 and there's no change and, they really shut it down and the clerks are given instructions that they shouldn't, or that they don't have to respond to those requests, then I think that probably the industry will shift to doing a statewide criminal background check, which is these court rules do not apply to that background check, but we're not there yet. I think, when we were in the midst or coming up on like a July deadline earlier in the year for Michigan, was more going in the direction of perhaps the clerks would be required to collect a copy of the candidate's authorization to do the background, or a copy of the candidate's authorization to release public record information to the background screening company, or possibly some sort of registration of consumer reporting agencies or registration of researchers in that state. So I think we'll see some action, something will happen here in Michigan. Lord help us, in the last 45 days of the year, before that court rule goes into effect. If it doesn't, if it comes to that, I think we'll still see some courts that will still be willing to provide that information. And then for courts that are not, that just shut down, I mean, hopefully employers have something to say to those courts, but I think probably in the industry will shift to more of a statewide criminal record there instead of a county level court record.
Great, thank you. Those are all the questions that I'm seeing, unless anyone else had additional questions.
Hi, this is Elijah from.
All right, well, if you guys do have some questions after the webinar, feel free to, oh, we have one person.
Okay.
Someone raised their hand, but I was just saying that if you have any additional questions after the webinar, please feel free to email us and we'll get back to you. And thank you for everyone staying and attending and joining us today. We will pick a winner for the Apple Watch and email you if you've won. Thank you.
Thanks, bye.
Hello, Monica. I will go ahead and get that updated for you. And